Hey guys, welcome to my legal classes. This is Ganesh Pujari and we were discussing the powers of the court when it comes to Probation of Offenders Act 1958, and this is the second video in that series. In the first video, we have discussed the two important sections, that is section 3 and 4 with 7 case laws, and in this session I am going to discuss 4 important sections, that is 5, 6, 8 and 9. Section 7 is pertaining to the confidentiality of the report submitted by the probation officer, where there is a power of the court again, and section 13 also gives certain power to the court in appointment of the probation officer. I'm not going to give too much focus on that because I have discussed those provisions when I'm discussing probation officer. So I am limiting this video only to these 4 sections, that is 5, 6 and 8, 9, and bring case laws here and there. With that brief, I'm getting into my first slide, which is on section 5. Section 5 is very easy, which discusses about power of court to require released offender to pay compensation and cost. While releasing the offender, court has two discretion. One, ask him to pay the compensation for those who has caused the injury or loss, and also ask him to bear the cost which are spent towards the proceedings. So these are the two rights are available with the court while releasing such offenders. That is all about section 5. Section 6 is one of the most important section as far as the Probation of Offenders Act is concerned, which discusses about restriction on imprisonment of offender under 21 years of age. As I have already discussed, if any offender who is committing offense for the first time in his life, that means he is a first time offender and he is below 21 years of age, and the punishment for his offense is not life imprisonment or death punishment. In such cases, he need to get probation, and if the court is denying to give probation, in that case it has to very clearly give reason in writing that why it is not giving such a chance or why it is not giving probation. And further it says that while doing so, he need to consider, that means the court need to consider the report by probation officer, where the probation officer will mention all the information related to the character, the physical and mental condition of the offender, and then go for the final judgment. Now there are 4 important case laws I have brought to give a clear perception on section 6 of this particular act. The first case is Sanchu Ray versus State of Assam. In this case, the accused was of 19 years and he had no criminal antecedent, that means he never had a history of commencing any such offenses, so he got probation. In the second case, Abdul Qayyum versus State of Bihar, accused was 18 years and he convicted the theft under section 379 of IPC and got punishment for the same, because the reason given by the court was he was in contact with hardened criminals. However, Supreme Court said that there was no such report mentioned in probation officer's report, so he need to get probation. The third case, Ishar Das versus State of Punjab. Here the accused was 21 years but he was not given probation, and the reason was he was involved in food adulteration, which is a severe crime, and the punishment went along with Food Adulteration Act because this was concerned with the health of the society. So here both the age was less than 21 years and he was commencing the first time offense, and the punishment is not life imprisonment or death punishment. Even then he got punishment because this is a sensitive issue, which shows that the probation aspect is not a compulsory, it is the discretion of the court. The fourth case, J.K. Prasad versus State of Bihar. Here the accused was 21 years and he found guilty under section 326 of IPC, which discusses about grievous hurt by dangerous weapon. Here probation was declined because he committed the crime with premeditation and the punishment for that was imprisonment for life, so he did not get any probation. These are the 4 case laws you can refer while writing answer for section 6. Section 8 gives the power to the court to make variation in the conditions of the probation. It can increase the period, it can decrease the period, it cannot increase the period to more than 3 years from the original order, or it cannot reduce to less than 1 year from the original order. That is the condition one need to remember. Now here the important part is whenever such variation is made, the same shall be reported to the offender as well as the sureties, and if any surety is not agreeing to sign after making such changes, a new bond will come into place, and if the new bond is not coming into place, then the court has the right to give punishment to such offender. That is the important aspect you need to remember. And while all these are happening, the important role is played by the probation officer. His report will be given high importance. On the basis of inputs given by him, the court will decide what exactly to vary in the complete probation order, and if it seems like there is no need to change anything, then it will continue with the same order. This is all about court's power to make variation in the conditions of the probation as per section 8. What happens when an offender fails to observe the conditions of bond? That is precisely what discussed under section number 9, which is all about procedure in case of offender failing to observe conditions of bond. Here what happens, court will warrant to arrest him or give summons to him as well as his sureties, and then hear the case, and till the hearing is completed, it can either put him in custody or grant him bail with or without surety. And after conclusion, if it is concluded that such offender has breached the conditions of the bond, it can sentence him to the original offense whatever he has committed, or ask him to pay 50 rupees fine and continue with the original bond conditions. Now if he fails to pay that 50 rupees fine, in that case the court can give him the punishment for the original offense. This is 4 important aspects you need to remember when it comes to section number 9. So in the last 4 videos, we have discussed the objects of Probation of Offenders Act, features of the Probation of Offenders Act, the probation officer, his duties, functions and reports, and then we have discussed in last 2 videos on the powers of the court, and that is sufficient as far as the Probation of Offenders Act is concerned. So with that, I am concluding the entire series on Probation of Offenders Act with 5 videos. Thank you so much for watching me. Please subscribe my channel. Please like, share and comment my videos. All the very best for your exams, and thank you so much for watching me.